Okay, welcome back to the COVID-19 Asian Mediation Forum 2020. Thank you for joining us back, and we hope you had a refreshing break. We'll now proceed with the panel discussion by the regional and international experts. Before we start, a general reminder that the panel discussion will be conducted in English language with simultaneous translation into Chinese language. Zoom audience may choose to listen to the Chinese translation by clicking the Translate button at the bottom of the Zoom app. In our second panel discussion, we'll be having the topic of global pandemic crisis, regional corporate counsel perspective on contractual performance and dispute resolution concerns. The speakers will discuss on the corporate counsel experience in dispute resolution during the COVID-19 pandemic, the focus on mediation laws and practice development in the region, effectiveness of cross-border private mediation and online mediations, and AIADR's role in providing regional ADR support. Today, we are very honored and privileged to have the global panelists, including Attorney Arlene Lapuz Ureta, who is the President of Legal Management Council of the Philippines, Mr. Thavakumar Kandiahpillai, who is the President of Malaysian Corporate Counsel Association, Dr. SUBIR BIKAS MITRA, who is the Honorary President of the Federation of Indian Corporate Counsel Association, Ms. Neoh from the Singapore Corporate Counsel Association, and Mr. Reza Topobroto who is the past president of the Indonesian Corporate Counsel Association, ICCA. I'm very pleased to welcome the moderator of the session, Mr. Anil Changaroth, the Director of the International Relations of the Asia Pacific Corporate Counsel Alliance, APCCA, and who is also a fellow of AIADR, to start with the session. Let us welcome. Thank you, Mr. Anil.
Thank you very much. Welcome, everyone. Good morning, good afternoon, good evening. I know we are now about 25 minutes late into the program. So I will dispense with the introduction and just like to highlight a couple of things before we start on. As you know, the topic is global pandemic crisis, the regional corporate counsel perspective on contractual performance and ADR concerns. We have put together all the heads of the various associations in the region, and we all form the Asia Pacific Corporate Counsel Alliance. Some takeaways, the start of some takeaways from this morning's sessions, the keynote speakers all spoke extensively about what ADR is about, what mediation is about, how it's going to be effective for industries and then parties using it. The first session, we had an incredible first session that dealt with various aspects from Mauritius to Bangladesh to UK to China as well. Also speaking about mediation, and they talked about a little bit about how whether or not mediation can be something that parties can agree to, whether it's binding, and so on and so forth. So in this session, what we're going to do is that we're going to take you down the path of experiences from Malaysia. Kumar, the MCCA president, from the Philippines, Attorney Arlene, who's the president there, from India, Dr. Mitra, who's the Federation of Indian Corporate Counsels, from Indonesia, the APEX, Asia Pacific Corporate Counsel Alliance's Secretary General and past president of the Indonesian Corporate Counsel Association, Reza, and from Singapore, Lynn, who was formerly the vice president of the Singapore Corporate Counsel Association. All right, and what I'm going to be doing is basically I've got a set of questions that I'm going to ask each of them to deal with, and we've agreed that each of the speakers is only going to take a minute or two to discuss the same topic, so we get a perspective from the whole region as such. And the first question is this: what is your role in your specific named company and organization? All right, and with that, I'd like to start with Kumar first, out in Malaysia. Just tell us briefly your role in your company. So we set a framework for all of our discussions to follow the questions that will follow as well. So Kumar, over to you, sir.
Thanks, Anil. My role was head of legal. So basically everything to do with legal disputes, compliance, so on and so forth.
All right, and you were with Shell before, and thereafter you had gone on to one other company, and then you're taking a break at the moment now.
Yeah, for a couple of months, taking a break now.
And the company before that was?
Sapura OMV, which is a joint venture between Malaysia, Sapura, and OMV AG of Austria, is oil and gas upstream.
Exactly, incredible. So you see, the reason I asked that is so that we get a perspective of your specific industry, and then we can put that back into the topic in question that leads up ultimately to discussing the mediation rules that AIADR has in place. Next, Dr. Mitra, over to you, sir. Are you gonna unmute, sir? Dr. Mitra, unmute, please.
Extremely sorry. Yeah, good morning to each one of you here present here. I mean, from India. Yeah, I come from a company that is the gas utility infrastructure company, primarily engaged in transmission and marketing of natural gas. We are required to lay pipeline for the transportation of natural gas. So we have a pan-India presence, and we are a giant Maharatna company representing India for sourcing of natural gas as well. So we have our headquarters based out of New Delhi, the capital of the country, and we have a pan-India presence. So at the headquarters, we have got a strength of around 25 law officers dedicated for this purpose. And in fact, all our arbitration, the bid venue, seat and place, we generally operate from New Delhi. So it is a centralized setup. And as you understand that, looking at the government of India policy, our natural gas share in the energy basket is only 6%. We are planning to get it enhanced to 15% or so. So have entered into large number of commercial contracts with US, Middle East, Russia, so on and so forth for sourcing of natural gas in the form of LNG.
Yeah, thank you very much. That's very, very informative, because leading up to the next few questions and moving from arbitration to mediation, for example, your perspective on those things will be good, very interesting. Next, Arlene, Attorney Arlene from the Philippines.
Hi, Anil. So I used to be the general counsel of Metro Bank until I retired, and now I serve as the senior legal counsel of Nissan Philippines. Of course, the first one is in the banking industry, and this one is my present is in the automotive business.
Brilliant. Again, you see the variety of the industries that we're going to. So again, ADR and how you deal with that. Coming back to Dr. Mitra, he had mentioned about 25 law firms that he deals with and arbitration issues. We'll come back to that as well. Sulin, over to you, Sulin.
Sorry, just trying to get the mute button off.
Thank you
for the warm welcome, and hello to everyone who's joined us from many places in the world. I'm currently in the F&B industry, specifically beverages and canned food. I'm the General Counsel and Company Secretary of a main board listed company on the Singapore Stock Exchange. Before that, I was for many years in the semiconductor industry as well as in the consumer electronics industry.
Thank you very much. Thank you very much. And last, Pak Reza from Indonesia.
Hi, Anil. Corporate Counsel for I think about more than 15 years in total legal profession, more than 20 years. So currently I'm working in Indosat Ooredoo, one of the largest telco company in Indonesia. My responsibility right now as the SVP of the senior legal advisor to enabling the transformation of the legal, regulatory, and government relations in the company. So not directly as somebody who is leading the lawyers to do the field on the field works, either corporate, commercial, or litigation, but more about enabling the transformation of our structure itself. Prior to Indosat, prior to the telco industry, I was in Microsoft as a legal director and corporate affairs for about 7 years. I think that was the time when I had a lot of experiences deal with every aspect of lawyering, especially as an in-house counsel, and dealing with a lot of technology issues as we are engaged in that sector.
Okay, thank you. Next, so everybody, I hope all the participants have got a sense of where we are coming from. We've got oil and gas, we've got banking, we've got F&B, and semiconductors, we've got regulatory. Now I'm going to go to the second and third question and then combine those questions. Basically, and then my next question to the panelists is this: how has the COVID-19 environment changed your operations and the performance of contracts? All right, so how has the pandemic affected the performance of contracts and the way you deal with your both internal and external? And I'd like to start with from the slightly regulatory angle and then ask Reza that question. How has your company, or how have you and your team been dealing with the pandemic and the fallouts from the pandemic in terms of contract performance?
Okay, so one thing for sure that we have to deal because of the pandemic is, first of all, it's about the internal collaboration, not only among us as the legal team, but also when we deal with our internal clients. And thirdly, is about how to deal with the authorities. In this will be including the court, the judiciary institution, and also with the law enforcer. Nobody feeling grateful about the pandemic, but for me, something like quote unquote is some kind of a blessing when I'm performing my role. How to transform the corporate, the legal and government relations team in the company, how not to make people, to change the mindset, to work more efficient by using the technology, and change the culture to be more digital and more online. So pandemic, which require everybody to work from home remotely, from far away from one another. By having this situation, we have no choice other than to do it right away. Things that have been planned in advance long time ago suddenly becoming very fast in terms of the planning to change the process and the tools and the system. So there are some initiatives which used to be still on the plan, and we still actually have a long schedule to roll out or to go live, immediately become effective right away. But now we used to be quite conservative, looking at how to apply the digital signature in our documentation. Now it's everywhere in our company, not only for the legal documents, but for all other correspondences. We already apply that kind of. And for example, the contract approval used to be manual, which sometimes took for about, most of the time, for about 30 to 50 days for someone to get the approval, being the contract being approved by the approvers who has the authority in the company. Now it may take only 10 to 12 days maximum, because we are using the online system.
Thank you. Sorry, you had one more point to make. Is that right?
Yes, in terms about dealing with the government, for the government relations team, because the government itself, they're very concerned about to avoid, prevent the infection, the spread of the virus itself. So the awareness of working online is also growing in the right way over there. So most of the interaction, most of the meeting deal by online. That's completely changed the way of our working. And in terms of the permit and licensing, I think in Indonesia we have applied that for the licenses in the central government, the online system since few years ago. So the challenges, how the local government, the provincial level, able to applicate the same way in their process. I think I pause at that one, because if I continue to the court dispute resolution, maybe we can.
We would come back to that. We'll come back to that. We are leading up to that next question. So thank you. Very interesting perspectives on regulatory requirements, digital signing, and all of that. I'm now going to go to Sulin and Attorney Arlene, because we'd like to hear from your point of view on performance of contract, and whether there's been delays in contracts, whether there's been in the banking sector and the finance sector, what kind of effects that it fall out from the pandemic. Lynn first, please.
Okay, I can't comment on the banking or the financial sector, but I can talk about the viewpoint from, let's say, the F&B industry that I'm currently in. So my company is a very old company. It's 120 years old. It's called Yeo Hiap Sing. So if anyone drinks soya bean drinks or chrysanthemum tea, that's Yeo Hiap Sing. We were classified as an essential services provider. So that allowed us to, have a workforce, continue production, and thereby not have the shutdown that many other companies who were not classified as essential services providers, were forced to do. That's all for good reason, of course, because the pandemic was really spreading. But as a result, as Reza also pointed out, everything had to go online. And I was 4 days into this new job and I had to work from home. So it was quite a different experience, very challenging to get to know your new company just after 4 days of meeting everybody. And then we all had to work from home. But the challenges were overcome one by one. So for example, our company was one of the first to hold our AGM under the Temporary Measures Act completely online. That one required a lot of hand-holding from external lawyers who also were faced with a situation they had never been faced before. So that was an online AGM. We had issues with frustration or force majeure contracts, force majeure clauses being referred to. And we dealt with them, of course, on a case-by-case basis. Some contracts were a lot more significant or expensive than others, so that required a lot more attention. But I think I'm probably going to generalize by saying that many companies, such as ourselves, we take a practical approach. We're there to do business. We want to cooperate. We're not using a force majeure clause or frustration concepts to try and get out of a contract. We want to have the relationship going forward. So, you cooperate with each other, you agree with each other how to manage the situation going forward. Tech solutions, again mentioned by Reza, of course, were very useful. And in fact, they are completely essential. For example, Zoom, as we are using now, all of us have to go on Zoom. Signatures are a bit more difficult. Some contracts still require wet signatures. And I just found that recently from a counterparty based in Thailand. So if anyone is dialing in from Thailand, it's something that I'm interested in. Wet signatures, I understand, are still essential to ensure that the Thai party is bound by the contract. I'll leave the rest to be covered by Arlene.
Thank you. Lynn, before we leave that, I thought it's also important that I pick off some of the things that we all are discussing and address them straight away. Interestingly, both you and Reza had mentioned about signatures and digital signatures and all of that. I just like to share a quick point on that. Commissioning in Singapore, you're allowed to do that online and virtual. Notarization is not allowed. We in Singapore have notarization that requires both our certification and an authentication by the Singapore Academy of Law. So it hasn't gone online and allowed. Interestingly, Attorney Arlene would recall a couple of months back, we had a webinar in Philippines, and I spoke on that, and we were talking about the digitization and virtual signature. And I started off the briefing or my talk saying that no, notarization you can't, you will not, is not allowed. But the Philippines, the participants or the speakers spoke very interestingly about blockchain contracts that are on blockchain and so on and so forth. So if you have them on a blockchain platform, they are highly secured. So why can't you then have your notarization virtually? So it's something that we're going to be looking into in the future as well. So I just thought I'd quickly stop there. Arlene, your views on performance of contract, COVID-19, and how it's affect banking, financing, and so on, please.
Hello. So for the Philippines, considering my current company now, our contractual performance is adversely affected by the pandemic since we are a distributor of imported cars. And of course, the first thing affected by the pandemic at the outset in March would be the delivery of the imported vehicles from our suppliers. So that's a major issue, coupled with, of course, the quarantine conditions and the stoppage, temporary stoppage of the business operations in the country. So our dealerships were all affected. Nissan has dealership agreements with different companies. So each of our dealers faced performance in terms of sales. So of course, here the important thing is that they were able to move to the digital kind of marketing, and they were able to eventually pursue their businesses later on when the economy was opened much later in the year. But the important thing is the obligations under the contracts. And here is where the importance of the in-house counsel lies, because the important thing is how to address those supposed defaults or failures to comply with the obligations under the contract. What we did was that we are for conflict avoidance. And what we did, of course, is that we did not call on defaults or invoke force majeure procedures for our obligations, on the other hand, to our other companies like payment, but rather we ask that the obligations be given additional period to be complied with. And that was something that our region appreciated, because it's a different approach. Instead of saying, no, you have failed to perform the obligation, you have to pay, what do we do? But we said, we'll be giving you time, or we can agree on a mutual delivery date, for instance. So that's how we approach it. And this is where I can see the significant role change for in-house counsels, because we are not now just giving ordinary legal advice, drafting contracts, but during the pandemic, the role has become significant in the sense that we have become strategic partners, and we have become business advisors, so that we are how the business goes forward, moving on with after the new normal has been in place here in the country. Now the different scenarios, legal setup of the businesses have been consulted with in-house counsel. So for instance, one major thing is, even in our regional operating headquarters, we have to rethink, reevaluate, and see the legal compliance matters that we need to address given the situation right now. So it's very critical, the role of the in-house counsel now.
Thank you, Attorney Arlene. Again, both you and Sulin have spoken about a little bit about an aspect that we are going to lead into after we speak to Kumar and then Dr. Mitra on the same area. That aspect is this. Sulin mentioned a cooperative approach. You mentioned a need for avoidance, and how it's critical that the in-house lawyers are there to facilitate this. Sulin spoke about force majeure and frustration. You spoke about that, and how while you're trying to satisfy the obligations under the contract, you also want to balance it at keeping peace and so on. So it really is going to lead to the next set of questions after I finish with the next two speakers, as to how dispute resolution can be there to facilitate in-house practice and solve those problems. So again, very, very interesting points. I'd like the participants to consider some of these things that we're talking about. Throw in your questions in the Q&A box, please, and we will deal with them. I've already started to see a couple of questions. But coming back to the point about performance of contracts in the pandemic and coming out of the pandemic, Dr. Mitra, your views, please.
Yes, I mean, I agree that, with the pandemic, there are difficulties, and there is no doubt that it has caused enormous delay and prevented or hindered the performance of the contract, and the parties failed to meet the contractual obligations. In fact, apprehending this issue, Government of India, before the declaration of the lockdown itself, has come up in saying that the pandemic period would be treated as a force majeure. But since the contract were in force and the contractors were not in a position to meet the contractual obligation, so the beneficiary used to impose penalty out of the provisions of the contract. So the whole issue moved to before arbitration and other places. Law point got examined, as per the common law, until unless the contract is completely, frustrated by virtue of impossibility, the one cannot get rid of its contractual obligations. So the question came up, whether the pandemic qualifies the major penalty event, force major event or not. But luckily, our company is, its company has grown over the years by leaps and bounds, and have a strong realization that we have grown because of the significant contributions made by our extended family members, the stakeholders, the vendors, suppliers, and the consumers. So therefore, we took it very seriously. We remain engaged in a continuous dialogue, so as to ensure that we do not land up in creating disputes. Rather than, we have created a committee, we call it Samadhan Committee, which is the resolution committee, actually comprising of the cross-functional member, so as to ensure that the quarterly closure of the contract takes place, and all the residual issues are flagged and resolved by the resolution committee. So we have a concept, because GAIL is always perceived as a non-litigant company, because we believe in more on ADR and not on arbitration of such. We believe in conciliation and the mediation, so as to ensure there is a settlement to the disputes, rather than litigating the party to the court of law or through the arbitration. So our approach is completely different, basically.
I think it's very interesting points. Again, I know participants, I'd like you all to pay attention, to some of the very interesting things that are being discussed. Two aspects of what Dr. Mitra spoke about is incredibly interesting. He said one about the force majeure and what the government of India stand was taken. For those of you who are not very familiar, I'd like to just quickly mention to you that force majeure is a creature of the contract. It has to be in the contract and set out as a term of the contract. And that's how force majeure works. Whereas frustration is a common law principle, and you can always turn to that, right? So here we have a situation where the Indian government decided that the pandemic was going to be deemed as a force majeure, and then applicable, and the provisions that would follow through would be applicable. It may not be the same for some of the other jurisdictions. We can talk about that a little bit in the Q&A as well. The second aspect of it, Dr. Mitra spoke about, is also very interesting and relevant, because it's going to lead up to my next two sets of questions and ultimately deal with dispute resolution. He spoke about the fact that there were strong relationships between the stakeholders, the vendors, the consumers, and it was critical for his company to constantly be engaging. So, the underlying point of this is the fact that people are saying, the speakers here would all testify to the fact that they ultimately don't want a fight on their hands. They don't want to end up in arbitration, and therefore it leads us to an interesting aspect of mediation, which we will discuss eventually. So the last speaker on this portion is Kumar. Again, Kumar, just to re-emphasize, we're asking you about how the pandemic, you see the pandemic affecting contractual performance and obligations. I appreciate the fact that you haven't been with the company for the last 2 or 3 months, but what is your take overall, sir?
Yeah, interesting. For us, just like what Sulin said, we are in the essential services industry. So a lot of exemptions apply to us in Malaysia. So we could run our office, and okay, the people who could work from home, like me and the management staff, we work virtually. But the, as I say, the spanners got to be turned and the platforms got to run. So helicopters got to fly. So those ones were exempted and they could go on. But we had some interesting challenges. The oil and gas international technical crew, so to speak, it's a very mobile and international crew. So we are an essential services industry for Malaysia. And if we're operating in, we do operate in many other countries. So we are in Australia, we are in Mexico, we are in New Zealand. Where you're operating, you will be deemed an essential services industry. The funny thing that we've had to face was, funny or strange thing, again, it's all unprecedented times, when you go through other countries in between where you do not operate, things become very interesting. We had one interesting challenge where we had some technical people who needed to fly, and this is not a question of we disputing with them, we're all working together and bending over backwards to do whatever we can. Needed to fly from the Philippines to offshore to Kuala Lumpur and then offshore in Malaysia. They didn't really have a problem with we don't have a problem with Malaysian government, but we are not operating in the Philippines as an oil and gas operator. We are just dealing with a technical person or persons there. We found, interestingly, they couldn't fly from Philippines to Malaysia. This is early days of the pandemic. There were no direct flights. So again, necessity is the mother of inventions. What they did, they flew to Dubai and flew from Dubai to Malaysia. So some airlines made a hell of a lot of money in between, but not too bad. They were only delayed by about 48 hours, or slightly less than 48 hours. And literally they flew over Malaysia the other way, 6 hours, flew back, and the thing got done. So people get very creative. Another interesting thing we had was, your point about physical documents and stuff. Mine was more in relation to bank guarantees. Banks are quite notorious when it comes to physical documents. And when you take a bank guarantee and place security in place, again, there's a revolving credit and so on and so forth, we need to free up the security. Banks are quite scared about releasing a guarantee, because bearing in mind the other party can claim until you return the original document. We had the other party emailing and sending a PDF signed letter saying that they will not make a claim on the guarantee, and therefore they are fine with us getting back the guarantee. But the bank said, we need the physical guarantee back, failing which we can't, treat it as null and void, because somehow or other, someone could make a claim so long as it's an on-demand guarantee, by the way, undisputable on-demand guarantee. So again, we had this interesting issue with the bank. What do we do? So we had a tripartite agreement, almost like a foregoing of rights agreement. That party, the bank and us, had to sign a separate memorandum and agreement to say neither shall claim blah blah. The bank still said, I can't quite release that because it goes against, because our central bank will regulate this stuff and whatever. But I can't quite release it fully because in our books it's treated as a guarantee, because for us, until the guarantee comes back, this is a major multinational bank, by the way. So we sympathize and empathize with what they say. We can't cancel the guarantee because it's all booked in the books as debits and credits and payments and dues and whatever. We can't just look away. So what we will do is we will categorize this amount a bit differently, but we can only deem the guarantee cancelled upon physical. So we had to work around it, just like earlier speakers said. We're going to get very creative. So we come up with immediate tripartite agreement that what people will do, and capture how to move forward, and yet the bank complying with its headquarters and global business requirements and the secure documents. So interestingly, we managed to solve the issue. So again, very creative. So it's not just on our part. We had with all three parties or multinationals.
Thank you.
We had to come very creative and get this done. So very interesting times. And coming back to your point about disputes, when the unthinkable happens and people do not have precedence, in a way it is good to avoid disputes. Lawyers get less gung-ho because everybody likes to say, I have read the House of Lords case or the Supreme Court case and I know what the outcome is. And they say, oh my God, I have no idea what the outcome is going to be. It's like throwing a ball and hoping wherever you land. So people then get a bit creative to solve things because outcomes are unclear. So there's no more goalposts. People say just kick the ball and you will figure out later whether there's a goal or not. So most people will say, look, let's figure out not to score a goal. Let's try to keep the ball in play. And until we figure out what the goalpost looks like, let's not try getting penalty kicks. Over to you, Anil.
Thank you very much. Again, very interesting points, and I would like to take some of these in Q&A, because you talk about the angle of being creative and in coming up with options. I'd like to talk a little bit about that later on in Q&A. What I want to do is this. We have another 4 minutes or so before I can open up to Q&A from the participants. We are actually bringing back the program back on time. If we wrap this last 2 set of questions in the next 5 minutes or so, we would still have about 20 minutes or so for Q&A and then participants, this thing, and we'll be back on time right now. So again, I started off by saying that I had about 6 or 7 questions I wanted each of the speakers to attend to. I've now paired up the questions, and then the next set of questions I'd like to pair, or the last set of questions is this. In looking at your functions in your respective companies and dealing with the pandemic and how it's affected people and how you react, and Dr. Mitra's point about really keeping relationships going. My next question, the next set of questions is basically this: appropriate dispute resolution. I do not say alternate, because we are no longer in the world of alternate dispute resolution. We are in the world of what is most appropriate. Now, coming from your companies, where some of the companies may be traditionalistic, and anything and every matter must be either in court or in arbitration, how have you and your companies considered the best way of avoiding disputes, avoiding conflicts, and resolving disputes, and then looking at the array of appropriate dispute resolution mechanisms? I'd like you all to talk a little bit about that. For this, I'd like to start with Arlene, because Arlene is the one who mentioned how you look at the obligations and you want this key point she said about avoidance. I'd like Arlene to start off, and then I go to Dr. Mitra, because Dr. Mitra really emphasized the essence of what in-house lawyers have to deal with, dealing with their consumers, dealing with their stakeholders, and so I'll come to him next. So Arlene, talking about avoidance and managing contracts, obligations, how do you feel from your banking industry in your company? Do you all still rely on traditional methods of dispute resolution, going to court or going to arbitration? Or have you now started, like Kumar has said, being creative in the approach of resolving disputes? How do you feel about that?
Yes, I'd like to actually share with you our experience in my company, because in the midst of the pandemic, we were really engaged in a huge litigation. As you well know, the Filipinos are very litigious. So actually, the case started with, 3 cases in court. So a criminal case, a civil case, and then there was an arbitration. So during the pandemic, this came about. So we went through arbitration to resolve a certain dispute about terminated dealership. But I'm happy to note that what ended it, actually, this long-standing dispute, which started with that litigation, was a mediation. However, in the Philippines, we have a so-called court annex mediation. In the midst, prior to the trial of the case, the parties are referred to the Philippine Mediation Center. And before that, before when we went through that stage, we have ongoing arbitration. As I mentioned, this is the first arbitration and online hearings held in the Philippines in the history of the PDI-RCI. So this one, it was also resolved immediately during the pandemic. But what is surprising is that in the mediation, which took only about, I think, 3 settings, and the parties sat down together and discussed the dispute, it ended very well, in the sense that a compromise was reached. And now it ended what is supposed to be years and years of litigation for this particular issue. So in other words, here, the key here is the counsel again, because the approach should be proactive. And I think our management agreed to that proactive approach of pursuing mediation or settlement, going beyond the conflict, because sometimes, we want to uphold the principles behind the move of management, and if necessary, to prove that we are right in court. But the advantage of mediation there is that, you don't look for the person or the party to blame, but rather how to move forward the business. And I'm very lucky that because we have a president, or our management is so geared towards moving the business, especially in the pandemic. It's something that we want to avoid, considering the many failures already in the different businesses. We don't want this other distraction of a litigation, all the expenses and trouble of litigation distracting the business from pursuing a viable business for the company. So it's really very important to have this modes of to resort to an appropriate, as you said, it's no longer alternative, because we all have this in our experience. But this one was the most appropriate thing at that stage, because it ended it right when we needed to have something eliminated immediately.
Attorney Arlene, I thank you very much for that, because you brought to light a very important point that it's not impossible and you need to look at options. In the first session before us, right, there were discussions about whether mediation, how it works, whether it's enforceable, whether it's binding and all of those kind of things. What is critical, I think we're hearing from the in-house counsels here today in this session is this. In-house counsels are pivotal and essential for trying to control and manage everything. And nothing is set in concrete, and the world has changed so much that you can't really be set in concrete and then say, sorry, we are in arbitration and that's the only way it's going to go, right? And you've just given us a perspective of that from a live experience. Over to Dr. Mitra, over to you. You also mentioned before about an arbitration, and then you spoke quite a little bit about your company and your ecosystem of the company and what is critical to you all. So how do you see ADR and the cost savings and all of those things for your company, sir?
Right, Anil, in fact, we the law officers headed by me, of course, have drawn huge inspirations from one adage of Buddha. It says that hatred is never ended with hatred, but by love. A misunderstanding cannot be ended by argument, but by diplomacy and conciliation with empathy. So our philosophy is very simple, that parties in disputes, they look for a mechanism which is cost effective, time bound, and it brings finality. And if possible, to create a win-win situation so as to continue the business relationship. If you look at that options, you'll find even within the ADR, arbitration does not serve that purpose. It is hugely, expensive. Of course, there are, the amendment that have taken place to bring the timeline. But yes, it creates a win-lose situation. It creates a broken relationship, because we, the organizations, having very limited number of, the contractors or the vendors with with a very highly skilled, skill set, they are not available, at abundance, and therefore we have to continue our business relationship with those vendors only. So arbitration, it has become a pre-litigation process, because anybody who is aggrieved with the decision of the arbitration award, he goes for challenging the award under section 34 and 37 of the statute. The point I'm trying to make, way back in 1980, when unsettled model of conciliation came into being, the government of India, framed a legislation. We call it Arbitration and Conciliation Act. Conciliation got the statutory recognition. So in our organization, we have created a conciliatory rules, and it is working fine. It has rather worked magic. In fact, many of the disputes which are pending, languishing before the arbitrator or pending before the court, under section 34, challenging the award, or under appeal under section 37 of the award, or even before the Supreme Court under SLP, those who are brought to the fold of conciliation, and the success rate is more than 90%.
Incredible.
A huge success, In fact, we are the pioneer, and our policy framework is now being copied by across the, PSUs and the public sector undertakings and the large corporations.
Yeah, for the benefit of the participants, let me just remind you, Dr. Mitra is coming from India and he's speaking about India. Every time you go and look at disputes and problems in India, people say the millions, the cases and the backlog are in the millions. But look at this, we're hearing from an in-house counsel telling you that there's an approach that's put in place and it's effective and it's conciliation and so on. It's also a good point to lead up to the end of our discussion before after we finish with the rest of the speakers, to talk about the AIADR's mediation rules, right? So, but it is so interesting to hear from India that there are incredible options. We still have Reza, over to you. Just a quick couple of minutes on dispute resolution from your Indonesia and your company's point of view, sir.
Thank you, Anil. So during the COVID-19, the challenges, of course, because the mindset that has been in place for the people who are in charge in the judiciary system. I hope you don't mind if I'm sharing this based on my personal view, not representing the opinion from the company where I'm working. The challenges is always about the mindset, right? The mindset about the dispute resolution, especially in the court, is by having everything physical. The pressure, actually, the initiative already coming from the government. Since a few years ago, the government released the regulation about the electronic system for the service to the public. And then the Supreme Court, before the pandemic happened, already released the court procedure for the litigation in court. But however, again, for the implementation in the court, there are hundreds of district courts in Indonesia, and the direction still from the Supreme Court still give the authority for the judges to decide whether the trial will be online by teleconference or video call or by physical trial. So because the mindset still using the old perspective, tendency of the judges to require everything to be physical still there. And the support of the infrastructure still not sufficient. We, as lawyers, as in-house, expect that the system of the filing the petition, filing the lawsuit, response, counter response, will be facilitated by the tools that is centralized, managed by the Supreme Court. But in reality, the Supreme Court still give that delegate that system to each district court to manage by themselves. So what happened is the district court in Jakarta, probably it won't be a problem. But what happened to the district court, which is located far away from the capital, already in the area that is near to Australia, near to Papua New Guinea, in the east part of this country, that still be challenging. Yeah. And then what happened is, rather than using the tools that is available online for all the lawyers who are disputing in the court, the registrar only, what they can do is require the parties to submit everything by email, but even the infrastructure is not good enough, so they don't have the official email address, so they just expect everyone to send a Gmail. So can you imagine the security, the data protection, a lot of issues will be involving here. The security will be also involved. Okay. So that's the challenges that we're facing right now.
Yeah.
The spirit is there, but not yet spreading equally to all stakeholders of the dispute resolution.
I think
We're talking about the conventional Anil.
Yeah, so thank you very much, because it then leads us to the last two speakers on this set of questions, and then before we open up to answer the questions from the participants, interestingly, you talk about the difficulties or the complications that can arise from dispute resolution mechanisms that are available. Sulin, over to you.
No, I'm an accredited mediator, an associate mediator with the Singapore Mediation Center. I think same as you, right, Anil? So we know the issues that comes with mediation generally. Sometimes it's parties' unrealistic expectations that mediation is like your own private judge. They mix it up and they think that you as the mediator will be able to help the other side settle by telling the other side how lousy their case is. So mediation has still got great chances of success, provided I think both parties come to the mediation center or the ad hoc mediation with an expectation to give and take. I think Dr. Mitra referred to a win-lose if it's an arbitrated case. In mediation, we like to say that it's a win-win, right? That both parties, if we both are willing to compromise, we'll walk away. It's not one party right, the other party wrong, but both parties at least walking away with, a relationship or walking away with some resolution. And as we all know, a mediation agreement can be enforceable. It can be signed off, it can be enforceable, but it will be extremely sad if that resulted in a second litigation. I think it still has some way to go, although I still believe that Asia is a good leader in mediation. I still think also that in Asia, mediation has been very much part of our culture, where it originated with small village heads coming together to help to mediate between two warring factions in their village. And I think that's still a mindset that we have, or embedded in our culture, and I'm very proud of that. In terms of whether corporates will embrace that, I think yes, because like the Philippines, we do have court-annexed mediation. Some are absolutely compulsory. Family court, for example, where there's a divorce. There's criminal mediation as well practiced in the Singapore courts. I help out in a commercial mediation or the small claims as a volunteer mediator. So I'll just stop there. I think there's a lot to be said about mediation in our part of the world.
Thank you, Sulin. Interesting again, you mentioned about annex court mediation. In session 1, my buddy Anand Jadu from Mauritius spoke a little bit about the lack of court annex mediation. Again, Dr. Khalid, another buddy of mine, in the first session spoke about mediation, ad hoc, and institutional mediation out in Bangladesh. So interesting points as well. Again, it all ultimately leads up to the AIADR. My apologies, AIADR. What it's doing insofar as mediation is concerned. Incredibly, in the first session, the keynote speakers today spoke about all of the AIADR's mediation rules and regulations. We're going to go into that in a little bit, but we want to finish off with Kumar. We started with him, and just tell us about ADR and how you find it in in Malaysian corporations. How do they deal with ADR?
Yep. On my part, okay, I can't go into details about anything which my company actually did in dispute resolution. So I'll take a broader view of Malaysian companies and with members of my association. The one thing that comes across with my own experience and also that of my colleagues, which it is quite, I think, latent. Everyone knows this, but it's not come out in this discussion. Is mostly when you go to ADR, whether it's mediation, arbitration, litigation, you would have already had not just your in-house counsel, you would have already had external counsel on board because you're worried about limitation and time and so on and so forth. My view is it's very key who you appoint as your external counsel. A lot will be said about that. In fact, there's almost the elephant in the room. There's some external counsel who are geared for fighting, whether it's arbitration. In fact, they may even try to make arbitration like courtroom, because in a way, to put it bluntly, they like grandstanding. I mean, nothing wrong, because that's how I was a litigator for the first 9 years. It's fantastic to wear. I didn't have to wear wigs except on my call in the UK, but it's fantastic to wear a robe, stand in an open court, and hold court literally. And everyone, I mean, even the judge or whoever, including the media, is looking at you. You are the star. It's a high. I cannot deny that. But you got to balance that against your client's needs. So by very nature, if you appoint a star performer litigator, you're paying for the star. When if you watch the movie The Gladiator and the guy said, I don't want to fight lah, the whole movie would have been a failure. So the same way, you can't appoint a star and say be passive. So you got to choose the right people. So you can't say, die, without mercy or whatever, and make it mediate. So if you chose the right law firm, who have got the best method, I would think is this: law firm or practice with a breadth of performers. They can call upon. In fact, it's always nice. In one of the recent matters, I heard they have one of this crazy, they say bad, crazy, whatever, expletive litigator who will almost want to like have his next kill. But we didn't bring him in. He's known to take blood, so to speak, even if he doesn't care, whatever. Crazy guy. This is an international big law firm, medical settle firm. But we didn't use him. We used the corporate lawyers. Knowing this is a crazy guy who'll go bonkers, I can't say too much. Both parties realize it's not worth going for blood, because these are people going to behead each other. So let's negotiate. So it's very important to get your external law firm the right ones, because if you don't, you're going to come back to square one. So I'll end with that.
And I'd like to take that last point, very relevant point, and lead into the question and answers, because there are several questions that the participants have put up. We will deal with that. I'd like you all to do me a big favor, that when you are dealing with the questions, look at it in light of, this last point about picking the right person to deal with your matter. I'd like you all to look at it from the point of picking the right institution to work with in terms of dispute resolution. And that leads me to this point. If you take a look at the AIADR's mediation rules, right? Very, very interesting how it's set out. It starts off in the definition section as mediation of conflicts, disputes, or differences, whether it's contractual or legal relations. And it sets out a whole set of sections that clearly sets out how you go about commencing, how you agree to mediate, how you appoint the mediator, how you set out the roles of the mediator, how the parties are to function, issues of privacy and confidentiality, the conduct, the settlement, and so on. So here we have the AIADR's mediation rules that clearly sets it out in a clear framework. And if you look at that and then deal with all of the aspects that we've discussed about what you all face in your respective companies, let's take a look at the questions now. I'm going into the chat box under the questions, and I'm looking at the time from 12:56 onwards. We have someone called Prasad, right, who said, would you like to know the perspective from Reza, how he sees the future of online dispute resolution in Indonesia, and what challenges the court and regulators should deal with? Now, please remember, we've got a couple of questions, and therefore we have three or four questions here. So we want to keep it short and sharp. So Reza, the question was addressed to you, and they're asking you on your views of how you think online dispute resolution may work.
Thank you for the questions. So Anil and the rest of the audience and the panelists, the questions about the future of online dispute resolution in Indonesia, I still thinking Indonesia have the positive future, because the intention from the government, the regulators, even from the Supreme Court, is already in place. How to transform the way managing the dispute resolution in the conventional court. But again, the implementation on the field, especially from hundreds of district courts in different of levels of district courts in different cities and provinces, it's going to be really depend on the infrastructure, the IT infrastructure. So in this case, it will be depend how the government to drive more pressure to create more open regulations to enable the government institutions in establishing the good and sufficient IT infrastructure that able to support this kind of system.
And
Second thing is about to change the mindset of the people, the stakeholders of the court resolution itself. For the arbitration, I don't see any problem because of they are more close to the business environment. They already apply everything, and the infrastructure is quite well supported. But the challenges will be: do we have the right infrastructure, the sufficient infrastructure for the court? And then the second one is the mindset of the stakeholders in the court system itself.
any other views from any of the other panelists insofar as this question? The question is that how do you think online dispute resolution may work? Just a quick one-liners from anybody else, because I have a couple of things to mention about that as well. Any of the speakers?
I can just chip in on that. I've done a couple of online mediations for the state courts over the past few months. And I must say that it is a challenge to do it online rather than face-to-face. The breakout rooms, the technology, things can interrupt, obviously. I had some interruptions to my Wi-Fi bandwidth, which was inconvenient and also embarrassing as the mediator. And not being able to see parties face-to-face did require some overcoming. I don't know if the other mediators, volunteer mediators, encountered the same issues.
Okay, so if none of the other panelists, if I could just add in, last week I spoke in Jamaica, last Thursday I spoke in Jamaica on online dispute resolution because I've written 2 papers on online dispute resolution from 2016 onwards, and it sets out how it can be applicable in a lot of fields. Some of the discussions that we've had, not just in Jamaica, but elsewhere as well, people are concerned that with online dispute resolution, if you're going to arbitrate, it's not as personable as being in the presence of the parties. But I took a different view. Can you imagine, instead of, if you're sitting as an arbitrator, I've sat as an arbitrator, if you're just looking at what the witness speaking, you're only looking at the witness speaking and you can't see the faces of everybody else. But in an arbitration that's online, you get to see everybody's reactions and how they behave. Someone else has also highlighted this issue about whether or not the witness is going to be coached and prepared in the background. It doesn't matter. You're sitting as an arbitrator. It is a forum of natural justice. You have pleadings, you have documents, you have statements, you have all of those things. And it's not a problem dealing with all of those issues and taking in whether or not this witness has been coerced or not. So, there are reservations about online dispute resolution, but, the pandemic has shown us that we are going to go into an incredible world where disputes are going to be dealt with online. And I've said as a mediator, I've also sat in mediation, multi-party mediation online. Not a problem. In fact, where you see, this is my office. If you look further back, we actually had 5 parties here, 1 meter apart and appearing on the same screen. And it was not a problem. So, online dispute resolution is something that will take another day. I am very, very sure the AIADR has got works in place on considering all of those aspects as well. The next question we had is this. Given the nature of mediation in which mediators know and understand their experience, options, circumstances, which allow the parties to close in for an amicable settlement, my question is, do you think disputing parties should engage independent mediators to represent them to conduct mediation on their behalf with or without the involvement of lawyers? All right. I suppose the question is this, whether or not they can go in there and to have the matters mediated without lawyers on board. So I open this again to the panel. Your views, please. Anyone? All right. Let me just warm it up. Sorry. Yes,
I'd like to speak on this issue.
Yes, sir.
In fact, very rightly you pointed out that, the success of be it mediation or conciliation, depends upon the mechanism or the structure that has been put in place. So you need to have a proper structure to make sure that it works. For example, in GAIL, mediation courts in India is yet to gain ground. But the conciliation event, we decided that we will not be involving legal fraternity. We took a very conscious call that the conciliation, we cannot allow them to go in the hands of the advocates and the law firms and the judges of the high courts and the Supreme Courts. So what we decided, we have engaged only and only the captains of the industry as conciliators. We have created a panel of conciliators from the legal fields, from the commercial fields, and also from the technical field. But they are essentially the captains of the industry.
Okay. Thank you.
So when they conciliate, they understand the perspectives and they bring the parties to a point of settlement. And that is how it has got an astounding success.
And I suppose
because the moment the former judges of the High Courts and Supreme Court, they are somehow guided by the Evidences Act, Civil Procedure Code or something like that. They can't get rid of them. And in the process, the essence is lost.
So, sir,
and we do not permit parties in disputes to bring the advocates to plead for them.
Yeah.
So we have a structure, great structure in place. Yeah. So when GAIL represents, there is a committee, cross-functional committee. They represent the GAIL. They take all decisions. And when they come to a point of settlement with the support of the conciliator, at the end of we enter into a conciliatory agreement duly authenticated by the conciliators, and there is no legal recourse. Further legal recourse is available to the parties.
Yeah. Thank you, sir. Your point essentially is the fact that you may not need lawyers if you have clear structure and framework. Again, I think I should share with you, Samadha up in Delhi is the court annex mediation center, and they deal with incredible number of mediations every day. I've visited with them late last year as well. So there are frameworks and structures in place that can deal with it. So any of the other panelists, your views on whether or not it's necessary to have lawyers on board when you're going to get matter mediated, and then, or do you want to just go directly to mediators yourself? Anyone else? Sulin, yes.
Sure. So I take the point that Reza made earlier about the mindset of the different stakeholders involved, and I have come across both the black sheep lawyers where they are advising the clients not to settle during mediation, at all costs, so that the mediation fails. Unfortunately, that's a mindset, but I'm very happy to note that seems to be a minority of external lawyers. I think most external lawyers I've dealt with as a mediator are pro-mediation. Yes. They tell me off the record what their clients are, interested in terms of their interests rather than strict legal rights. Exactly. We all know that coming to mediation and standing on strict legal rights is just dooming the mediation to failure. The mediator is not an advocate, he's not a judge, he's a facilitator, he or she. And therefore, addressing Jason's question about the nature of mediation, that's the whole nub of it all. If we come to mediation with an expectation that the mediator will think I'm right and the other fellow is wrong, then that would doom the mediation to failure, because mediation really is about trying to understand what each party's interests are and then trying to meet those interests, not strict legal rights. So
Sulin, yes, you made a very good critical point. You see, people who are going to turn to mediation as an appropriate dispute resolution mechanism must appreciate what mediation is about. And that's why
lawyers, yes.
Yeah. And then that's why I thought when I started the Q&A session, I thought it was very important to highlight the AIADR's mediation rules and how it starts off by saying mediation of conflicts, disputes, or differences. So, it clears up and opens up a whole avenue for you to do that. Now, I appreciate that we are now at 1:45, 1:46 exactly. We should end here, but because we started about 25 minutes late, and because we are right smack towards the end of the question and answer, I thought we take the liberty of maybe just going a little bit 5 minutes in. I have not asked permission for it, but I want to do that because I think it's important that this aspect of mediation and lawyers and all of that comes squarely back into looking at the AIADR's mediation rules, and it sets a flow and how you can do that. So if you look at the rules and you feel that it's not necessary that I have lawyers on board, you might just take that option. So, the rules are set out there so clearly, and Dr. Mitra highlighted this point about the conciliation and how it's set clearly, so it's irrelevant. So I'd like to, the other speakers, if you have views on this, please share with us. And then I'll take the one last question that I see that came in at 1:39 p.m. I'll deal with that question after this. Any others on this aspect? Yes, Pak Reza.
Yes, thank you, Anil. So I think as an in-house lawyer, as an in-house counsel, so refer to your commenting to your question just now, it's very important to look back at the basic again. Very important for us as the number one person, as the GC in our company, to be confident. Be the one who understand our company, our internal client, our business, the risk that is waiting over there that may affect the business of our company that we work for. So involving external lawyers, involving law firms, in mediation or any other kind of works, it really depends how we confident as a corporate counsel to handle the things by ourselves. So the issue is not about only about involving in-house lawyer, but it's more basic. It's about the confidence. And the second, probably the only reason that why we have to really involve in-house lawyer is only about the bandwidth. If about in technical, in reality, there's so many things that in our plate. I believe it's better we as in-house counsel should be play in the frontliner, and the in-house lawyers who are more specific, the external lawyers who are more specialized in expertise in certain matters, support us in research, analysis, preparing the administration books, especially if you are the in-house counsel or general counsel who are sole contributor in your company.
Yep.
So be more confident. You know more about your company. And the mediation rules is much more simple, especially the AIADR that we already have right now. And don't be hesitate to do it by yourself.
Thank you, Arlene. Anything else to add on that?
Yes, just to echo what Reza mentioned, the role of the in-house counsel is very critical. For mediation, probably it's not important that we bring in the external counsels, or they can be there, but the ones discussing or negotiating would be the parties themselves. And the in-house counsel comes in as part of the parties. Meaning when I joined in that mediation, it's because as part of the management team, because I know the operations, what the business interests are, and at the same time the legal rights. But it's not, the second point is the attitude or the mindset or the perspective of the in-house counsel. It's important that the counsel should not be very legalistic, because the objective is different in terms of in the case of a mediation. So it's very important that counsel should now change the mindset when you go to a mediation, so that you achieve the purpose of your party or the company that you work for.
I think Attorney Arlene, that's a very interesting point. That's really about what this session, this panel is talking about, from the in-house perspective. But I'd also like to add one point that, as in-house counsels, you all have had to turn to external lawyers. I think it's important to note that just because the question was asked whether we need lawyers at a mediation, and Sulin and I spoke a little bit about the framework of mediation, and therefore whether it's really totally necessary. Sometimes it's critical, because if you don't get the agreement that you're going to enter into drafted in the right form, dealing with all the eventualities, you're going to have a problem. So, I remember 3 years ago, I spoke in Malaysia on mediation, and everybody's saying that their rice bowl is going to be taken away and all that. But I'm a dispute resolution practitioner. I've never found it difficult. you still have a lot to contribute in mediation. You still have a lot to structure in mediation. You still have a lot to discuss in mediation. So it's not impossible. I think we are at the end. There was another question, but the question has been seemed to have been taken away. So I think we can round off. I hope that the participants enjoyed this session because we had an inside view from the real people on the ground. The in-house counsels, we've had a wide array from banking to F&B to oil and gas to tech companies. You've seen our APCA, the Asia Pacific Corporate Counsel Alliance leaders here in discussion, and they've given you an opportunity of first-hand experience of what how to deal with disputes, how to come out of the pandemic, look at collaborative approach, working together. Dr. Mitra spoke about, really understanding what is needed by the shareholders, the stakeholders and so on. And so I have to say this, that we are going to come out of the COVID-19 with a lot of issues, yes, but nobody wants to go to a full-length, blown-out dispute resolution mechanism to get it dealt with. They don't want, it's not going to turn into a dispute. We are going to turn to avoiding conflicts and then settling conflicts way ahead of time. And it's perfectly timed, this conference, by the AIADR and the mediation and the rules that they have in place that really puts all of this together and gives everybody the right of going to an appropriate mediation dispute resolution mechanism moving forward. We are at 1:52. We've taken 7 minutes beyond the time. I'd like to thank the panelists. I want to share one big point to everybody, the participants. We set out the questions, but we never had a discussion about the questions between the panelists. We never had rehearsals. I did not know where each of them were coming, but I hope we've shown a seamless understanding and appreciation of the session and of what AIADR is doing for us and the rules that they have in place. Thank you very much, speakers, panelists. I hope the participants enjoyed an incredible 1.5 hours. Over to the host.
Yes, thank you so much, Mr. Anil. Particularly enlightening discussion on dispute resolution concerns from the Regional Corporate Counsel perspective. Thank you, esteemed panel, for sharing your experience and relevant consideration of mediation laws and practice development in the region, besides AIADR's role in providing regional ADR support. We are very privileged to have you joining the forum today. Thank you so much.
Thank you.